I almost dismissed it the same morning it arrived. A man suing his neighbor for her Wi-Fi password. That was the case, not a metaphor, not a summary of something more complicated. That was the filing, in a federal court with my name on the docket. I read it once and I nearly sent it back without a second thought. Then I saw the attachment. 8 months. He had documented 8 months of requests she had refused, notes slipped under her door, hallway conversations, emails to the building management office. Every date, every time, every decline, logged, organized, filed as evidence of her unreasonableness. He had built a file on a woman whose only offense was that she had said no and meant it. And I understood reading that file that this was not a confused man who had made a mistake in the courthouse. This was a man who had decided that persistence and righteousness were the same thing, that a court of law was simply the next tool available. My name is Isaiah Webb. I have been on the federal bench for 4 years, and I want to tell you what this room said back to him. If that is the kind of account you came here for, subscribe, hit the bell, and stay with me. Every subscriber tells this platform that accuracy is what people want, not spectacle. And before we're done, I want to know whether you have ever had to defend a refusal to someone who treated your answer as an obstacle. Write it in the comments. What I'm going to describe now, stay with every word of it, because what happened in that courtroom was not what either party expected. There are cases that come before me where the law is complicated, where I spend weeks in the record before I can see clearly what the facts require and what the oath demands, where I read the briefs, read them again, and still find myself at my desk at 11 at night working through a question that has not yet resolved itself into an answer. This was not one of those cases. What was complicated, and I want to be honest with you about this from the beginning, because I think you deserve the honest account, was deciding how seriously to take a man who walked into a federal courtroom and demanded a woman's Wi-Fi password. That was the question I had to sit with, not the legal question. That one answered itself in about 40 minutes of reading. The question I had to sit with was, what does a court owe to a person who has treated it as a louder version of a demand? What is the correct response when someone files a complaint, not because they have a grievance the law recognizes, but because they have a grievance the law is the latest tool for advancing? I want to tell you what I decided, and I want to tell you why. The complaint arrived on my docket on a Tuesday morning. I read it the same day. The plaintiff, a man I will call the neighbor, had filed a civil action against the woman who lived in the unit adjacent to his in a residential building. The action alleged, in the language the plaintiff or someone working on his behalf had assembled, that the defendant had unreasonably withheld access to a private wireless network in a manner that caused the plaintiff material harm. He wanted the court to compel her to provide the password. He wanted fees. He wanted, as best I could determine from the filing, to win. I read the complaint once. Then I read it again, not because it was legally complex, because I wanted to make sure I was reading what I thought I was reading. I was. What I want to tell you about is the file he had built, because that is the detail that stopped me from dismissing the complaint in the first 10 minutes and never thinking about it again. The plaintiff had attached to his complaint a document, a log really, of every request he had made to this woman for access to her network. Dates, times, her responses paraphrased in his hand. The note he had left under her door in February, the conversation in the hallway in March, the second note, the follow-up conversation, the third note, the email he had sent to the building's management office, the management office's response, which had told him politely but without ambiguity that they had no authority over a private resident's personal network and that the matter was between the two parties. He had been tracking this for 8 months. I sat with that for a moment. 8 months of documentation. 8 months of what he experienced, apparently, as a legitimate campaign for access to something that had never belonged to him. 8 months of treating a woman's refusal as a problem to be solved rather than an answer to be accepted. And at the end of 8 months, when the notes and the conversations in the building management office had all declined to produce the result he wanted, he had filed a federal complaint. I want you to understand something about what that means. Filing a federal civil complaint requires a filing fee. It requires a legal theory, something the plaintiff can point to and say, this is the statutory or common law basis for my claim. It requires the defendant to respond, which means the defendant must either hire an attorney or represent herself. And either way, it costs her time and money and the particular kind of stress that comes from receiving a court document with your name on it. He knew all of this. He had, after all, done the research. He had, after all, built a file. What happened over the weeks that followed is something I have thought about many times since. Not because it was extraordinary in its legal complexity, because of what it revealed about this man, about a particular kind of certainty that I have encountered before in this work. The certainty of someone who has confused persistence with righteousness, who has convinced himself that the intensity of his desire for something is evidence that he is owed it. She came into my courtroom having done nothing wrong. I want to say that plainly because it is the plain truth, and I think it is important that you hear it before I tell you anything else. She had received a request. She had declined it. She had received the request again. She had declined it again. She had been subjected to notes and hallway confrontations and the low-grade, unrelenting pressure of living 12 feet from someone who had decided that her answer was not a final answer, but an opening position. She had done all of this without escalating, without retaliating, without doing anything other than continuing to decline what she had every right to decline. And then she had been served with a complaint. She appeared before me with an attorney, a sensible decision given the circumstances. And she sat with the specific quality of stillness that I have seen in people who have been managing something exhausting for a long time and have finally reached the moment when someone else will have to deal with it. Not relief exactly, something more careful than relief. The posture of someone who has learned not to assume that rooms will go the way they should. I notice this. I notice most things about the people who appear before me. I spent 5 years representing people in rooms like this one. People for whom the quality of the judge's attention was the difference between the next decade of their life going one way or another. I carried that into this work. I pay attention to the people in front of me. It is the least the job requires. The plaintiff arrived with the energy of someone attending a proceeding he expected to conclude in his favor. He was not aggressive. He was something that I find, if I am being honest, considerably more revealing than aggression. He was certain. He sat with the settled quality of a man who has explained his position many times to many people and has not yet encountered anyone with the authority to tell him that the position is wrong. He looked at the room, at the bench, at the defendant, at his own attorney, with the mild proprietary interest of someone who believes the machinery is about to produce the result he came for. I have seen this before. Not this man, but this certainty. The certainty of someone who has, for most of their life, found that persistence eventually produces compliance. Who has learned that enough pressure, applied consistently enough, tends to wear people down. Who has never, or rarely, been in a room where the person across from them had both the authority and the inclination to simply say, no. Not as a negotiating position, as a conclusion. I asked him to explain the legal basis for his claim. He stood. He had clearly prepared for this moment. He explained that he and the defendant were, in effect, proximate neighbors in a shared residential building. That the building's infrastructure, the walls, the utilities, the common spaces, created a relationship of mutual dependence. That the defendant's wireless network, while technically on her private account, operated in a shared physical space. That her refusal to share access was, in his framing, an unreasonable withholding of something that the nature of their proximity had made, if not legally communal, then at least subject to the court's equitable consideration. He finished. He sat down. I looked at him for a moment. I want to tell you what I was thinking because I think it is honest and because I think it is relevant to what I decided. I was not thinking about the legal argument, which had not improved in the delivery. I was thinking about the file he had built. I was thinking about 8 months of notes and hallway conversations and management office emails. I was thinking about the woman sitting across from him, who had said no consistently for 8 months, and who was now sitting in a federal courtroom because no had not been a sufficient answer. And I was thinking about what it means to treat a court of law as the next escalation in a campaign that began because someone declined to give you their Wi-Fi password. I asked him a question. I asked him whether he understood that a private wireless network was the personal property of the account holder. He said yes. I asked him whether he had a contractual relationship with the defendant that might create any obligation on her part to share access to her personal property. He said no, but I asked him to stop at no. He stopped. I asked whether he had any statutory basis for his claim, any law, federal or otherwise, that granted a residential neighbor access to another resident's private network. He consulted briefly with his attorney. His attorney said something to him quietly. He turned back to me and said that they believed the court's equitable powers extended to situations of this kind. I told him I appreciated his confidence in the court's equitable powers. I told him the court did not share it. What I want to tell you about is the moment before I issued my ruling, not the ruling itself. That came clearly and without difficulty, because there was no cognizable legal claim before me, and there never had been. What I want to tell you about is the decision I had to make about what kind of ruling this was going to be. A dismissal was available to me. Clean, efficient, correct. No claim, case dismissed, parties instructed to bear their own costs. The defendant goes home. The plaintiff goes home having lost. Proceeding closed. I sat with that for longer than I usually sit with straightforward decisions, and I want to be honest about why. The plaintiff had cost this woman something, not a catastrophic something, but something real. She had received a court document with her name on it. She had hired an attorney. She had taken time off work to appear. She had spent weeks in the specific low-level dread of an active lawsuit, the checking of email, the calls with her attorney, the particular quality of a Tuesday morning when you know that somewhere in the federal court system your name is attached to a complaint. She had done nothing to earn any of this. She had said no. That was the entirety of her offense. I have the authority in cases of frivolous filings to impose sanctions. Rule 11 of the Federal Rules of Civil Procedure exists specifically for this, for filings that have no reasonable legal basis and that the filing party knew or should have known had no reasonable legal basis. The question was whether this case warranted it. I decided it did. I dismissed the complaint, and I imposed a fine. The amount was not enormous. It was not designed to be. It was designed to be something specific. The court's formal statement that this room is not available as a continuation of what had been happening in that building's hallways for 8 months. That a lawsuit is not a louder version of a demand. That when you take the decision to file a legal action against someone who has done nothing to you other than decline a request, you are not escalating a private disagreement. You are making a claim on the resources of the federal court system, on the defendant's time, money, and peace of mind, and on the legal process that exists to protect people with actual grievances. And that this court has a response to that. I read the ruling. I stated the fine. I stated the basis. He had not expected the fine. I want to be precise about what I mean when I say that. He had expected, I think, to lose the case. He was not so removed from reality that he had walked in confident of winning. The certainty I had observed in him was not the certainty of someone who expects victory exactly. It was the certainty of someone who expects to be engaged, to be treated as a party with a position worth arguing against. He had expected a proceeding. He had expected the court to consider his equitable argument and find it insufficient, and he had expected to leave with a dismissal and perhaps some irritation. He had not expected a fine. The fine made it something different. The fine made it a finding. The fine made it the court's formal statement, on the record, attached to his name, that what he had filed was not a close case that did not go his way. It was a frivolous claim. It was a use of the legal system that the legal system will not accommodate without consequence. I watched him receive that. I watched his attorney place a hand briefly on his arm. I watched him sit very still for a moment. That stillness, that is what I want to tell you about. Not as satisfaction. I want to be careful here because what I felt was not satisfaction in the way that word is usually meant. What I felt was something more specific. It was the recognition that the room had done what the room is for. That this woman, who had done nothing except say no and say it again, was sitting in a courtroom where someone had finally said no back, with authority, on the record, in a way that would follow him. I have been on this bench for 4 years. I was a federal public defender before that, for 5 years before that, and I sat across tables from people for whom a judge's decision was not a legal abstraction, but the next decade of their life. I carried that into this work. I carry it still. I pay attention to what decisions cost the people who receive them. She received this ruling. She sat with the same careful stillness I had noticed when she walked in. Not celebration, something quieter. The quality of a person who has been carrying something for a long time and has just been told officially that they were right to put it down. I thought about what she had endured before that moment. The notes, the conversations, the management office that could not help, the day the complaint arrived, the weeks of being a defendant in a case that should never have been filed. None of that was returnable. The ruling could not give her back the Tuesday morning she had spent worried about this. It could not give her back the money she had paid her attorney. It could not give her back the ease of living next to someone and not having to think about them. What it could give her was this: The record. The permanent record of a court that had looked at what had been done to her. The 8 months of pressure, the weaponization of the legal system, the treatment of her no as an obstacle, and had named it, had put a number on it, had said in the language courts use, which is the language that lasts, this was wrong, and here is the consequence. A lawsuit is not a louder version of a demand. I want you to hear that. It is a serious thing, with serious costs, that the legal system makes available to people with serious claims. When it is used as the next escalation in a campaign of harassment, when it is filed against a woman who has done nothing except decline a request, by a man who could not accept that decline, this court has a response. The response is not silence. It is not a quiet dismissal that sends both parties home as if they arrived with equivalent standing. The response is the record, the finding, the fine that says, you knew what you were doing and you did it anyway, and this is what that costs. I want to leave you with one question, not about this case, about your own life. Think about the last time someone treated your no as the beginning of a negotiation rather than the end of one. Not a no about something trivial, a no about something that was yours, your time, your space, your property, your privacy. Think about the pressure that followed, the second ask that came dressed as a reasonable follow-up, the third one that arrived with just enough grievance attached to make you wonder if you were being unreasonable. Think about what it cost you to hold the line. Think about the specific exhaustion of having to say the same thing again and again to someone who had decided that your refusal was a problem to be solved rather than an answer to be respected. That is what she came into my courtroom to defend. She had already said no. She had said it more times than she should have had to. She had said it to notes and to hallways and to a building management office that could not help her. And when none of that was enough, she said it to a federal complaint. She walked into my courtroom and she said it one more time, in the only room where it had the force of law behind it. I want to know, in the comments, whether you have been in that position, whether you have had to defend a refusal to someone who treated your answer as an obstacle. Tell me what that looked like. Tell me how long you held the line and what holding it cost you. I read every comment on this channel. I want to know your version of this. If what you heard today is the kind of account you have been looking for, honest, specific, from inside the room where these decisions are made, subscribe to this channel, hit the bell. Every subscriber is a signal to this platform that accuracy matters, that weight matters, that the truth of what happens in courtrooms is something people came here for. That matters to me. That is what I am here for. She is back in her apartment now. The record exists. The fine stands. Somewhere in a federal court file attached to a complaint that should never have been filed, there is a ruling that says, she said no, and she was right, and this court agrees. I hope it is enough. I think it is the most this room could give her. I believe she deserved to have it.